discussed there, there's questions made, there's recordings made, but General X appeared in the Regulation 10.6. Now, for me to deal with whether he's a suspect or not, in respect of anything to do with General X, I need to know what was discussed during the plea negotiations. And it's not just somebody sitting there and now we're drafting a 105A.
For what purpose? You are doing that for what purpose?
For purpose of invoking my right to silence on that. I can say,
no,
I've been
then
told...
you don't get me altogether. Then you don't get me altogether. We have already, please listen to me. We have already made common cause that there are issues in respect of which Mr. Matlala is able to deal with before this commission. Now, you are talking about issues that, post the plea deal, may also fall under the Section 35 dispensation that you are claiming. I have said, let's put aside all of that. So what you are telling me falls, according to you, under that basket. I have said, let's put that aside. And let's address our minds to those issues about which there is no question regarding them being heard by this commission. That is what my focus is on. And it's on that basis that I say to you, I do not understand your point about the plea deal and its relevance to my question. I hope you get me now.
Let me again try and explain to you, Commissioner, or Chairperson. I can only say to you, we've made common cause on the issue itself. But I can only tell you, as an officer of the court, which of those...
No, I will not give you time when you seem not to understand me. I am saying, I'm not interested in the nitty-gritty of what falls under the Section 35 bucket. I'm not interested in that nitty-gritty. I'm looking at the broader question of, on those issues on which there is no question whatsoever, which can be dealt with by this commission, and you've agreed that there are. On those questions, why can't those questions be heard before the criminal process has been finalized? Whether, even accepting, as you argue, that there are some issues coming out of the plea deal which fall under the Section 35 basket, even accepting that, you have said there are some which do not fall under that basket, and my focus is only on those aspects that do not fall under that basket. So clearly, what you've just said about the plea deal is irrelevant to my question.
With the greatest of respect, it's not irrelevant, Chairperson, because I cannot at this point in all, as an officer of the court, distinguish between what we can answer and what we can't answer. We can only say to you, the only things...
You will never understand me. Please go on to your next point.
No, I do understand you quite clearly. The only issues that my client can answer, Chairperson, at this point, that we say that we form common cause on is who he doesn't know on the list of the 10-6. The rest of the issues, if I may please finish, rest of the issues, I cannot say to you, I am prepared to answer this because I don't know if I can.
I have not asked you that. You are trying to answer a question which I have not asked you. I have not asked you that question. I have simply not asked you that question. I am asking you a general question. It has nothing to do with specifics, and that general question is, on those issues on which there is no question whatsoever, those issues, I will accept for a moment, for purposes of this debate, that there are plea deal issues that fall under the Section 35 basket, and which therefore will not apply to my general question. So I'm asking you this general question again, and it is this. On those issues which even you, whether today, tomorrow, or by the end of this year, there can never ever be a question about them falling under the Section 35 basket. On those issues, and again I repeat, this is a general question. On those issues, what would the basis of us not continuing with those prior to the finalization of the criminal process? What would the basis of not doing so be?
The only basis would be that the evidence will then be presented piecemeal. I've said to you, Chairperson, and I stand by it, The only things that he can say to you at this point, I don't know A, B, C, D, and E. The rest of the issues we cannot deal with. And I, with the greatest of respect, do not think it would be in your interest for him to sit here and say, I don't know this person, I don't know this person, I don't know this person. That's the only issues that we can form common cause on that he can at this point answer. We are trying to come to the Commission and answer what we can. The problem is, and I'm sorry to repeat myself, I can only do so if I know what he can answer is shown to me in black and white. I am trying to ensure that my client comes to this Commission and gives evidence to you that is to your benefit, i.e. the work of the Commission. And not for him to be to answer things that we as legal officers, and you've been in our position before, you can never allow a client to go on oath if you as the lawyer are not sure what he said there is right. I will not perform my duty as an officer of the court if I allow that. And for that reason, right now, I can claim privilege clearly on certain issues. I can say, this is my Section 35 issues. The others, I say to you, I can't at this stage because I don't know what's going on in the background. So it might even be, once I've got the documents that I think is necessary for me to decide it, that we can move on that. But right now, we can't. And I respectfully submit that based on the remainder of the issues that we've put here, that this Commission should allow him the opportunity to finish the trial. And more so...
Again, please tell me when you are done
yes,
responding to my question.
And then the last thing is, I think the thing that concerns me the most is, and we've taken the liberty of sharing a privileged document with you pertaining to the opinion. The one
I think that's something else then. Can I come in? Yeah.
And when that for me personally, is very concerning at this point in time.
When you referred to a piecemeal hearing, this is just for clarity. Does that mean you are going back on the earlier acceptance of what I posited to you, which was, is it something that can be done for this Commission to entertain proceedings that relate to issues that have nothing to do with Section 35? And I understood you to be saying yes. But now, towards the end of your submissions, you said, I don't know, I'm paraphrasing, I'm not sure of the exact words you used, but you said something like, it wouldn't be desirable to have a piecemeal hearing, something like that.
Yes.
Is that going back on what you said earlier, which was to agree with what I posited to you?
Yes. As I said, and the reason why I say piecemeal is all that will happen at the end of the day, Chairperson, is he will sit here and say, I confirm I don't know these people. And that is literally all we can do at this point. That is the only part of the Regulation 10.6 that we are at idem with each other. I say nothing prevents him from going under oath and say, I don't know person A, B, C, D, E, and F, and sit back. The rest of the issues, again, I want to emphasize, we want to cooperate. We've put it in our paper. But give us an opportunity to ensure that what we come to the Commission with is truthful. It's based on facts.
Another thing which arises from what you said in the context of the plea deal, and if I understood you correctly, you said this in the context of dealing with why a statement was not prepared. And again, if I understood you correctly, you made the point that you or your client had to wait until that plea deal process had been finalized so as to know whatever it is that related to the facts eventually. Here's a difficulty I have. Surely facts cannot change. Facts are facts. Mm-hmm. And I do not quite get it why Mr. Matlala could not have made his statement. He knows what the facts are, regardless of what the outcome of the plea deal were to be. He knew the facts, and therefore, from where I'm sitting, subject to your response, he could have said, these are the facts, and here are my responses to the notices that I have received.
Chairperson, the situation is...
Or just to finalize, the facts could not be this or that, depending on the outcome of the plea deal. The facts are facts.
No, it is different, because when people enter into plea deals, there's certain consensus reached, and it goes, it's dealt with in totally different way, 105As, than what would normally, as you say, admit certain facts. If you go on a 220 or 115A and you admit facts, it's a different story. A plea deal goes beyond it. So very often, there's facts behind it. As long as that 105A stood there and the magistrate has not ruled on it, our submission is that the issues there, he could not entertain his Section 35 rights on those. He could not come to the Commission and say, listen, I'm a suspect or an accused on this particular matter, and therefore I invoke my right to silence. It's a live process, and that live process has many complex issues behind it. So for that reason alone, he could not depose to that, to any affidavit here. I understand what you're saying, Chairperson. I understand what you're saying. But if he were to honestly depose at that point before Monday to an affidavit, he had to answer questions that we believe, because of him assailing from the 105A, he now has the right to invoke a right of a constitutional right.
But the Commission's interest would be facts in accordance with what Mr. Matlala knows. And that has nothing to do with whatever it may be that informed what he said for purposes of concluding the plea deal. So on that basis, I do not follow your response.
I stand by my response, Chairperson. I cannot, again, as an officer of the court, make my client say I invoke my right here and there and whatever, when I know in law the situation is that is a life process, and he cannot invoke that right at that point in time.
But I don't want to give, I won't say the first to the fourth. It could very well be, but we start on the first until he concludes his testimony. Uninterrupted. Thank you.
Thank you.
Chairperson, I indeed confirm that is the agreement. My understanding is that we start on the first and then it will continue until such time as we've reached the end. If I may just use an opportunity to just deal with one issue. I got a random message from somebody on my phone telling me that I'm not allowed to shout at you, Chairperson, or the other commissioners. I just want to make it plain that I don't shout, I just speak very loudly. Most people know that. So I am sure you didn't perceive it as shouting, neither yourself nor the other commissioners I spoke to. Just for people that don't know me, I speak very loudly. It's not shouting. Thank you very much, Chairperson.
If it gives you any comfort, Mr. van den Heever, let me tell you that a judge, when I was appearing in the Mthatha High Court, once shouted at me saying I should not shout at him. So
then we're in the same boat, Chairperson. I'm very happy to hear that. Thank you.
Thank you. Oh, one other thing.
Later in the morning, and I'm quite mindful of that witness. So that constrains me significantly as to how I respond. So I will try to be as brief as possible, and in so doing, perhaps to assist the commissioners. I would like to start with where my learned friend ended, which is an offer to file the statement in 2 weeks. That effectively takes care of the first part of the ruling, or was it the second part, but one part of the ruling of the 7th to file in 2 weeks. we have spent over an hour engaging, or my learned friend engaging you on matters that don't get to that conclusion. That's where she ought to have started and would have saved significant amount of time. I say this because on reading the affidavit in support of the application for postponement, one must bear in mind that we appeared before you on the 7th of July. Everything that is in that affidavit predates our appearance. And it is at that appearance, notwithstanding the facts as asserted in that affidavit, an undertaking was made. So if those facts were not relevant prior to the 7th, and the very facts, notwithstanding the very facts, they were able to make specific undertakings, which included filing by the 8th of July and appearing on the 15th, I truly do not understand how then they become relevant come the 15th. They revive, they suddenly become relevant. The challenge with this application is nothing in the affidavit speaks to the period between the 7th and the 15th. Nothing happened that even threatened the undertaking made to you on the 7th, Chair. So the question is, why must I entertain this entire argument, if not to waste the Commission's time? Mr. Matlala's legal representatives were informed by certain facts to conclude that they're in a position to make certain undertakings on his behalf. They don't come here and say, those facts have changed. They don't come here and say, since the undertaking was made, new facts have come to light that make it impossible for us to comply. So technically, that undertaking made is not worth the paper it's written on. And this is a complete waste of the Commission's time.
Can you,
Now,
sorry,
yes.
Mr. Lula. Can you please make me understand something Ms. van den Heever said on the 7th?
Yes, Chair.
Ms. van den Heever indicated that she was agreeing to the filing
Yes.
by the deadline that was indicated, something like subject to the reservation of Mr. Matlala's rights. Even as she said that, I wasn't sure in my mind what exactly that meant. What was your understanding?
My understanding...
Of course, maybe I should have asked, I should have put that question to Ms. van den Heever.
It's a subject, of course, to Ms. van den Heever confirming,
Yeah.
but I'd understood that the proviso was file on the 8th, subject to Mr. Matlala's right to supplement statement filed. That was the reservation made.
Because there could not be an undertaking to file, but at the same time not to file, an undertaking
yes.
not to file.
And in fact,
It's even wrong for me to refer to the latter as an undertaking. Yeah.
And in fact, that proviso was discussed amongst ourselves because of the tight timeline they then had to file by, having missed previous deadlines. The only way to cure any potential prejudice to Mr. Matlala was to agree and place on record that he reserves the right to supplement. We thought it is a natural way to go, and he's entitled to supplement whether or not he has reserved that right in any event. But to the extent that it was necessary to articulate it in no uncertain terms, we were agreed to that. So that was the proviso, Chair, that was not touched.
All right.
The filing.
Please continue.
Thank you. So at the end of the day, what the legal position is regarding Mr. Matlala's constitutional rights, as posited by my learned friend, is irrelevant for our purposes. She may very well be correct, she may very well be wrong, but it doesn't advance the issue any further. Those rights existed on the 7th when she made the undertaking, unless she said...
Before you move on to another point.
I've basically responded to your question.
Thank you. Let me tell you how my difficulty arose. It's because the affidavit does not clearly delineate the issues either at all or as clearly as you have done now. And that is because, for example, the application says the entire commission process must be postponed pending finalization of the criminal process. So it's on that basis that I then ask you, does that mean there are no questions whatsoever that Mr. Matlala could deal with before this commission? Now you have responded and said, no, there are. So there are issues that he can deal with before this commission. Now my next question is, why can't that happen before the criminal process has been finalized?
Because I, as an officer of the court...
At this level,
I'm honest with you.
No, let me finish. At this point, focusing only on those, this of course is not a ruling on whether we agree on the Section 35 point. That's something we're still to apply our minds to. But focusing only on the issues that can be carved out of the Section 35 issues. Why can't those be heard or dealt with by this commission before finalization of the criminal process?
So there's three reasons. The first I've already dealt with. I said to you that there was negotiations ongoing, and I need to understand in those negotiations who, what, and where. And without that, I cannot,
Are you talking negotiations relating to the plea deal?
Relating to the plea.
That's history now. I'm asking you about now. I'm asking you about now, please.
It's not history, because it's only if I have regard to those and those are handed over that I can come and say I can answer question A and B but not C and D, because it is clear from what we have been given that is a suspect on these issues. So you cannot answer that question. So that is my first point. I cannot at this point in confidence say to the commission, and I won't permit my client to deal with those until such time as I know what they have negotiated with him, what they've asked him, what he's committed to, what he's not committed to.
Is that not an issue relating to whether there should or shouldn't there be a postponement? And that's not what I'm asking you about.
No, sir,
I'm asking you about the precedence.
Yes,
Which of the two processes must precede the other?
But
So I understood you to be referring to the plea deal in the context of saying, prior to that being finalized, I do not know what to do. I must wait until the end.
No.
That's something else altogether.
No, that's not what...
It has nothing to do with whether. Once the plea deal is dead and buried, must the commission process wait for the criminal process? So the earlier issue, the plea deal, is finalization or even non-finalization, has nothing to do with the question I'm putting to you.
It does indeed, Commissioner. If you will permit me just to explain to you.
All right.
During a plea deal, there is much more than the simple wording in the plea deal that takes place. There's other negotiations that happens between the investigators, the client, and the attorney. And during those investigations, there's names that come up, there's information given, etc. And during that negotiations, a person potentially is, and I'm trying to keep it in the abstract, is told, you are a suspect on this matter. Let's say you're a suspect that you connived with General X to do A, B, and C. General X doesn't appear, for instance, in the plea deal.